I'm a man with a gift and I'm doing my shit like. Trying to get saved every day of the answer. I'm a man with a gift and I'm doing my shit like.
Hey, y'all. Can y'all hear me? Because I can't really tell. Hey, y'all. Yes, I can. All right. We're going to be handling it without Krisha for a little bit because she's got an emergency this morning. And so we're going to be waiting for Judge Boyce to start. So I'm going to go back and forth looking to make sure that we don't miss it. So if y'all just hang with me and talk amongst yourselves. Krisha is okay this morning, but they got some sort of a problem with the house because of the storms and stuff. I think she had some, I don't know, frozen pipes or something. But anyways, it's right in the room where she's trying to stream. So we're going to start without her. And I'm sure she's going to come in a bit. So I'm going to check and see what Judge Boyce and them are doing anything. We don't want them to start without us. So I'm guessing that I'm going to welcome everybody. I can do that. Let's see. Oh, boy, we've got KJ is here, and she's always trying to help out, and that is wonderful. And we really need, Krisha needs that so much, and all the support y'all give her, it gives her so much strength. So KJ is here, Fancy Nancy, Norma Gira, Medea here, 1979 ACR, Norma Gira, KJ is Norma. Let's see. Let's go on. Denise Hester is here. Lamezia is here. D9 is here. So let's see. I'm going to go back and check, y'all. So we don't want to miss anything while I'm poodling around here. So we've been talking about different things that we think might happen, which it's like the main thing is that we hope this trial goes on in April. However, they can figure out how to make that happen. That's what we want to have happen. And also, the fact that we've got both of these trials going on at the same time. And I noticed that Lori had some sort of a hearing that we will probably get minutes on later today. So we'll be glad to see that. And I'm just going to keep checking, y'all, because I don't want to miss it somehow. I see that other channels are doing the same thing we are. So we're just going to keep doing that. And Judge Boyce, I'm sure he's going to have a lot to say today. And he always surprises us with the things he does say. So with this being said, with the fact that Krish is not able to come in right now, if one of the mods or KJ wants to come in with me, I'll send you I don't know if I can send it or not. But KJ, if you have a link to come in, you can do that if you would like to. We've just been going back over the trial. Of course, we've been doing it in the lives that we've been having on Tuesdays and Thursdays, but also we've been digging in, trying to nail down what in the world that David Warwick and Melanie Gibb exactly were saying happened that Sunday, and trying to figure out how they were able to, like, in their hearings, were able to name people like the realtor and these people and never give a name for anybody to ask anything to. That seems very strange. And so there's just, it seems like the more answers we get, the more questions we get. So I'm going to check again, y'all. Just be patient with me. I guess I could share this tab instead. And let me see. I've got this. Oh, man. Okay. There I am. I'm not sure that I really wanted to do that, but here I am anyway. So I'm going to share the tab. There's my little kitty cat, one of them. Judge Boyce's YouTube instead of seeing me. And I'll keep refreshing that. So that we can see if something happens, we'll be ready for it. I thought it was very interesting. And I want to say that it was KJ that brought this up, but it may have been someone else. But in that they've said that that Pryor made these filings and he put them under seal because he wanted to do this kind of not in front of people, like we wouldn't find out or we didn't want to know about it, seems like. At any rate, that wasn't allowed and it was unsealed, and here we are today. So I'm going to go back and look and make sure and refresh, and here we go.
And that's all set forth in the order governing courtroom conduct that's in effect for this hearing. I'll note on the record that the state is represented this morning by Rob Wood and Lindsay Blake, prosecutors for Madison and Fremont County. John Pryor is here with the defendant, Mr. Daybell, and the court scheduled on shortened time today's hearing after receiving a proposed motion to withdraw as counsel. That was filed on January 11th. There was a declaration supporting the motion, also filed January 11th. Court reviewed those and determined that the motions originally filed under seal would be unsealed, and they were. The state then, yesterday on the 17th of January, filed a objection to the motion to withdraw. I'll also note that the court entered an order just this morning that unsealed the previously sealed order of the court as it related to a August 25th, 2023 order. And I've provided copies of that to council, but it does have some relevance to today's proceedings. So let me confirm that. Mr. Pryor, you would have already had a copy of that order, but from the state, Ms. Blake or Mr. Wood, did you receive the court's order unsealing the August 25th from last year order and a copy of that order?
Yes, Your Honor, they were provided to council today.
Okay, thank you. And they're doing construction right through the doorway here, so council could speak up probably into the microphones, unfortunately. Try to make the record as clear as we can here. Mr. Pryor, are you ready to proceed on your motion?
Yes, Your Honor.
All right, and who will be arguing on behalf for the state today?
I will, Your Honor.
Ms. Blake. All right, Mr. Pryor, then, as I mentioned, I've reviewed the motion. If you'd like to submit arguments in support of the motion, you can do that at this time.
Judge, because of the microphone, may I have permission to remain seated?
You may, and if you just pull the microphone right up close there, Mr. Pryor, because of this noise from construction, that will be helpful.
And Judge, I was advised by your clerk that the microphones are doing quite well and that I should probably, and is my voice at this point acceptable, Madam Clerk, in terms of the tone? It's not washing out?
Yeah, it's fine. We're picking it up. Thank you.
Judge, I appreciate the court releasing the order from 8/25/23. The court's well aware ex parte that I filed in January of 2023, well over a year ago, a year and 7 days, a motion to seek additional counsel. And the court identified the fact that at this point, being privately retained, that Mr. Daybell may not be eligible for having additional attorneys represent him. And I'm relying on the court's interpretation of that statute. And Judge, what has transpired, and as a matter of procedural history, in middle to late of 2022, I started the process of seeking additional counsel. I believe that was probably about 2 years ago. I started seeking a year and a half ago, seeking the possibility of getting additional counsel aid me in this case when I realized the magnitude of the discovery. That process involved, Judge, going through the list of qualified attorneys on the Public Defense Commission list. I took the process of identifying all of those folks and then reaching out to all of them. And the ones I didn't speak to directly, I spoke through the various public defenders, the people who ran the public defender's office. I went through that list and at that point was unable to find anybody that was available to do this. And it's no secret, it's reasonable common knowledge that the Public Defense Commission is having a difficult time finding death qualified attorneys to represent in these kind of cases. I then contacted the commission on a couple of occasions and spoke to their one of their assistants and their directors and got the idea of maybe reaching out to out-of-state attorneys and did the process of contacting about 6 out-of-state attorneys to see if that was a possibility as well. And again, with no luck. Shortly thereafter, I went through again and went through the same process, looking through the list of qualified attorneys. In January of 2023, about a year ago, I reached out to the court and said, listen, it's going to require additional counsel. Mr. Daybell is indigent. He doesn't have the ability or financial ability to hire another private counsel at this point. And the court went through its analysis and thus came up with the order that you released today, Judge. What has transpired, Judge, is that approximately in Judge, I don't want to misstate, so I want to be very careful about this. But I believe it was in October of last year, I reached out to a private attorney that I know and asked him if he would consider becoming death penalty qualified to aid me in this case, and he agreed to do that and started the process. He has been in relative contact with the Public Defense Commission, and at this point, up until today, when I spoke to him this morning, the holdup is the CLE, but that, whether it's no fault of his or the Public Defense Commission, and I'm not putting any blame, but at this point, there's no appointment, there's no decision that has been made, and I'm really unclear because the commission won't tell me his status, only I can get relayed by what he's telling me. But I came to realize in late December that the amount of work that I'm going to need to perform before the trial was of such an extent that it would, in my opinion, create a situation where not all of the things that needed to be done for the trial commencing in April 1st could get done. This put me in a difficult situation. I want to relay to the court.
When you say December, what, December of this last year, 23?
December of 2023, Judge.
All right.
I realized at that point when there wasn't a decision about him being appointed, and the court obviously directed with its order that you'd be willing to compensate another attorney to help me. But in December, I contacted the attorney again. I was in relative frequent contact with him. And he said, listen, there hasn't been a decision. I said, please contact them, find out what the holdup is. Where are we on this thing? And since that time, it was more than weekly that I was communicating with him. Up to today, there still hasn't been a decision. I don't know what the status is, and there hasn't been an approval. At this point, this puts me in the situation where this court, I don't think, is obligated to appoint an attorney. Mr. Daybell has private counsel. And I want to state to the court that I don't desire to get off this case. I want to stay on this case, and regardless of Mr. Daybell's financial situation, I want to stay on this case. I could care less about the money. Mr. Daybell wants me to stay on this case.
Well, that's not really what your motion says, though, Mr. Pryor. Your motion says you want off the case because it's going to cost too much for you to work, the work it's going to take to get it through trial without compensation. So
Right, and that's correct, Judge.
this is an important issue for me today. Are you wanting to withdraw because you think you deserve to be paid for the work you do, which I understand, but when I'm considering the standards under Rule 44.1, which is discretionary under Part A, on a leave to withdraw, I may allow you to withdraw for good cause. And what I'm trying to determine is, do you want to withdraw because you're not being paid enough to continue through trial, or are you seeking to withdraw because you're simply not going to be prepared and ready for trial?
Judge, the situation is this, is that when I say to the court, and I'm saying that in all sincerity, I don't need to get paid for this case. The concern is this, is that at least at this perspective, Judge, I'm going to be doing this by myself. And it's going to expend a lot of resources and a lot of time that I'm not going to be able to commit to other projects or other situations. Now, obviously, I'm not taking on a lot of other obligations because of this case. Do I want to get paid? Everybody wants to get paid for what they do. Am I making that the only reason to withdraw? Well, it's twofold. Do I want to get paid for the work that I've done in this case? I do. I'd like to get compensated for the next 2.5 months and for the 2 months of the trial. And I do want to get paid, and I think it's fair. And Mr. Daybell and I had a discussion about this. Mr. Daybell expressed to me that he doesn't feel comfortable me continuing in this case if I'm not getting compensated for the work. And I advised him and told him that I don't need to get paid. I'm willing to do that. So if I'm not being clear, Judge, I'm willing to do it. Do I want to get paid and do I want to get compensated for this case? Yes. Do I think it's fair that I'm not getting compensated? I don't think it's fair. But it's twofold, Judge. The only way that Mr. Daybell is going to be ordered, or the only way the court can order Mr. Daybell getting additional counsel is if I withdraw. And that's the only situation that would cause the court to say, all right, Mr. Pryor's granted leave to withdraw because he wants to be compensated. Mr. Pryor wants to be paid for the work that he needs to do for the next 4 months. And Mr. Daybell agrees with me that it's not fair that I work for the next 4 months without being compensated. If the court decides to deny the motion, I want to make it clear, Judge, that I'm prepared to go forward and push this case to the end regardless. And I'm committed to that. Do I think it's fair that I don't get paid? No. Do I want to get paid? I absolutely want to get paid for the work that I do. And that's, you know, and if I was unclear in my my declaration, Judge, that's where I stand on this issue. But the only way for Mr. Daybell to get appointed 2 capital qualified attorneys, and the only, you know, and the purpose of getting capital qualified attorneys, Judge, is when the government has to pay for attorneys, they get to dictate what qualifications you need to be a capital defense attorney. I chose not to go through that process and get capital qualified, even though the criteria that they've established, I qualify. But at this point, I don't see any choice if I don't get assistance from another attorney to help me in this case. I don't have any choice but to withdraw. The primary reason is that there is no mechanism that I can see based on the court's interpretation of the statute that allows Mr. Daybell to get assistance mandated by this court unless I withdraw. But let me be clear. Do I want to get paid for the work that I'm going to do? I absolutely want to. And does Mr. Daybell want me to get paid? He does. Does he think it's fair? He does not think it's fair, and he wants me to be compensated. And that's where I stand on this. If the court decides that they're going to deny the motion and say, no, Mr. Pryor, I'm not going to let you off. I'm not going to harbor any hard feelings. I'm not going to harbor any dislike for Mr. Daybell. I'm going to go forward and I'm going to do the best I can. And I'm going to make an effort to try to find someone to help me, even if it's the day before trial. But again, let me be clear. Do I want to get compensated? Yes, Judge. Do I think this is fair? No. But by the same token, primarily, Judge, is the only mechanism I can think of to allow Mr. Daybell to get 2 capital qualified attorneys to help him with this case is if I step away and withdraw from this case.
Prior, going back to your preparation for trial, of course, this is a capital case, and if there's a conviction in the case, then under Idaho Code 192515, there's a special sentencing proceeding. And Idaho has adopted ABA standards for capital defense cases, and generally that requires, for example, the appointment of a mitigation specialist for the defense team as part of those proceedings. And I'm not asking you to reveal any defense strategy or even list a name, but the concerns I have here is you say you'll go through and do the trial, but I really want to know, are you really ready for this trial? For example, do you have a mitigation specialist that would be prepared in the event of a conviction in this trial?
Judge, if the court wants to have an answer to that question, at this point, I'd like to take a recess, close the proceedings, and disclose that issue because that is a trial issue and it's a trial strategy that at this point, I am not prepared to make an open statement on live TV about what my strategy is. If the court wants to take a recess, go in chambers, I'd be happy to discuss where I stand on this. In terms of the ABA standards, Judge, in terms of complying with the ABA standards, I'm aware of those standards. I'm aware of what that obligation is. But again, in terms of how I'm going to proceed in that manner, I would prefer to do that in either in chambers or in a closed proceeding.
Okay, and I think that's a fair enough request. Again, I'm not asking you to reveal trial strategy or publicly put that out, but these are legitimate concerns I have in weighing out whether or not Mr. Daybell is going to receive effective assistance of counsel in this case if you are permitted to remain on by me denying this motion. So I do want to get into that issue and discuss that. The state's entitled to know the answers to that as part of their objection to this motion. In lieu of doing that in chambers or off the record, it's got to be on the record. It needs to be in a sealed closed portion of the hearing. I'll determine under ICAR 32. And I think really the best way to do that, unfortunately, at the inconvenience of those in attendance here, is likely to clear the courtroom and allow that discussion to take place with only those necessary personnel in here to conduct the proceedings as part of a sealed closed hearing. So that's what I'll do at this point to go through those issues, and then we'll come back on in a public proceedings. So I would request that courthouse security and the bailiffs, if we could have everyone step out except for the clerk and the necessary security while Mr. Daybell is here. We will close this portion of the proceedings, and also for the bailiffs, if you could just make sure no one's within earshot of the a doorway as well, to make sure it's not carrying through on the microphones. And I appreciate your accommodating that. We'll also, of course, stop the proceedings from being live streamed, and then we will come back on the record once we're ready. We'll take a brief recess while that occurs.
All rise.
We're on a break, waiting for them to talk amongst themselves there. Hoping won't be long. And it's a breakout session. Can y'all see my little new baby kitty? No, little baby kitty, come over here. This is the new baby kitty that's not really a new baby. She's the rescue kitty, but she's wild. She'd rather go over there to that screen. And so I was really glad to hear Boyce sort of holding him down. He's like, so is it because you want more money, or are you not ready? He was really trying to pin him down on that, because whenever he wanted to get separated from Lori, like he wanted the cases severed, he was like, oh, we're ready to go right now. And she's in the dang mental home, and we're ready to go. We're ready to go. And then she comes out and wants a trial right now, and he's not ready. He's not ready. He's not ready. I mean, I'm not trying to defend it, but I think I know enough about it to go to court and talk. And not really. But then again, I didn't go to school for 8 years or however long it takes. I'm guessing it'll come right back up. So I'm going to look and make sure on the other. Yep, that's what it's doing. That is what it's doing. And so I really thought that Boyce looked like he was about to have some steam come out his ears a little bit. Looks like his beard is filled out, or he might have put on a little weight, but he really looked like he was about to blow. And but when you think about it, we have all questioned this. We have all said, how much money is that dang house worth? How, how can that be? And two, that's money that you're not paying your electric bill with. And so, of course, I know that, and even Boyce said this, that during the court, that he hadn't like looked at it or studied about it. He waited and heard it all as the jury did, as fresh as they did. And so that's part of their job, to kind of look at it, not without bias, but still, and yet, and it's coming up over and over through all these cases, and I'm just going to go on and say it, that, and we really should, we should pay attention to what's going on in Utah and Idaho and Arizona, because when the government becomes filled with religious people, no matter what religion it is, then it is very hard for the religion not to be fooling around in the state or in the government. Because it's like, and this is just an example, in Utah, the government is like 80% Mormons, but the state is only like 40% at this point. So that's, you know, this is what happens whenever. And, you know, if it's your religion, you might not think, well, that's not bad. But you see, this is an example of what just randomly religion can do. So we want to keep them separate. We want to be good people, good humans. Don't hurt nobody. Don't kill nobody. Have, be sure and make your, whatever your, you know, don't be trying to manipulate people. Tell them what your motives are. Let them know up front what's going on. That's what we all want. So I'm going to look at the comments, I guess, here. Does anyone know the address of the house? Yeah. Well, I think we all know the address of Chad's house. There it goes. Right there. You can Google it up.
Google that
Google
on
it up.
up. Google it on up. Sorry, I had to do that first. And then, yeah. Okay, my lighting's all jacked up. Y'all, I don't even want to tell you what the hell I've been doing. It ain't been nothing fun. Court's more fun. I don't know where to put this.
I'm going to back it.
Oh, great. What is up with my lights? There's nothing missing except for sunshine. All right. We had a effing water leak. Okay. Look at me. Jason was in the hospital again. Okay. I'm just like, I don't know how much more that I can take. I really don't. I really fucking don't. Sorry. Not sorry. It's just, we had a water leak, but we had water. You know, now we don't. But anyways, I know I worked for my Uncle Bobby, who is a master plumber in 4 states. And I worked for him for quite a hot minute. And, you know, I know that you're not going to have water problems besides the water stopping because it's frozen during an Arctic blast like we had. Yeah, I'm dry. That's what I'm saying. But as soon as it starts, you know, to warm up above 32 degrees, that's when you'll find all the water leaks. I mean, that's when that happened. So when I took a shower this morning and I was like, God dang, there's no water pressure. But I had hot, I had cold. I got through it. And I was thinking, okay, well, that's just because we've been running our faucets, right? Yeah, for 3 days, 3 damn days. Well, I think it was running since last night because it was 34 degrees last night through the night. Anyways, Jason got home yesterday morning, or I don't even know. It's just running in together. He had I don't even know because I slept. Soon as he left in the ambulance, I slept. And then I woke up to him banging on the door. Like, I opened the door and I was like, what? I'm so sorry. Anyways, Larry dropped him off. He had picked him up at the hospital, you know, bring him home. So thank God for him. Anyways, and they cauterized his freaking esophagus again. So yeah, there's that. He's still groggy though. Oh, Mark McGarry, take note. Whatever the outcome of this hearing, Chad remains locked in a cell. And that is the moral of the story. That's where thank you for that reminder. That's something I repeat to myself a lot. If they do let them out, him or them. I don't care. They better keep him over there. That's all I'm saying. And good luck. And then we say, and I know this sounds really insensitive when it's how it comes out, but if look at Casey Anthony, she's still living. So, yeah, you know what I mean. I don't have to go there. You can read my mind. But thank you all for the prayers. Always. I wish I didn't need them so damn much. I am not, trying to be a prayer hog. But geez, I mean, it's just so different since his strokes, y'all. It's heavy. And it's another loss, really, if you think about it. It's a loss from the Jason before that. I'm so grateful for everything. I'm so grateful for him. But it is, it happened. It is what it is. And it's a loss. It is. And it's a change in the dynamics of our relationship. And it's difficult and it's tough to see him struggle through that. Denise. Casey Anthony has hell waiting for her. Right? Right. Thank you. Thank you all so much. He's sleeping right now. Poor thing. It's hard to even, you tell him, like, I try to tell him in not an alarming way. I know what it's like to have CPTSD. I've been telling him for a long time. I'm like, don't startle me, and it just, boom, you can't help how you react. You can't. That's part of the thing, that I'd have it half mastered if I could do that. But ever since his stroke, he startles easy. He has CPTSD, I do believe. So now you got two of us, and we're like, bing, bing, we're trigger. Oh, you are backstage? I don't see you back there. Hold on, let me give you a today's link. Which, if you want it on your phone, then I'll have to do it from my phone.
I bet Krisha, can you hear me?
Mm-hmm. Probably an old one.
I bet she used the old link. Yeah, send her a new link.
Yeah, usually you can pop in on those, but I don't know.
Well, we got other things up though, so maybe that's it. She's in the other room.
Okay, KJ, I'm texting you a link. Good. I was gonna ask you beforehand to come on afterwards if you wanted to, but here you go, ma'am. I sent it. I text it to you. Yeah, you are Lori. Oh, God bless your soul, right? It sucks. It sucks. Is he okay? Are you okay? It just really sucks. It takes a lot away from you. There's KJ and the Ray. Let me pull her up. We'll talk more about that, Lori. Uh-oh. Oh, okay. Blah, blah. Oh, okay. Hey, girl. I'm sorry. Let me fix this. So, oh, no. Okay. One day. Where? The layouts are weird. Okay. You're on, though. So say hi.
Hello, everybody.
That's a new one. As soon as I figure them out one day, why won't it let you up there too? That's weird. The layout is weird. I'm trying. I mean, you're on. They can hear you. I just, Donna, just let me know whenever that comes back on. Please. I know you will.
So is it just me, or is John Pryor sitting on the fence? One minute he says he wants to stay on the case, and the next minute he's saying he wants to leave. I'm confused.
Mhm.
That's not at all what he said in his motion to withdraw.
Right. Remind us, because I'm sitting here trying to think. I didn't catch the first half of it.
Well, he's the first half of it. He's saying, he's talking about it isn't about the money, but then he turns around and says, "Yes, I want the money." It's like
yeah.
I mean, he's not making any sense about what it is he's wanting to do, and So he's going back in judges' chambers to talk about what? You know?
Because well, wait, the other thing was trial strategy. I heard that part. But that was having to, what is that? That's what kind of got me a little bit. I was like, so you talking about having a mitigator is trial strategy? How?
Well, if
Death
they do
penalty
have
strategy.
a mitigation specialist that's supposed to help through that second phase of a death penalty case.
Right. Once they are, once he's convicted, because he
Right.
will be convicted.
Right. And they have to have a mitigation specialist. And a lot of times they'll use those mitigation specialists as investigators too. But he did say that he tried to get someone certified
To
be
get
on his,
the,
to
yeah,
be on his team and everything. But it's like 1 second he's saying he just needs help and he wants money, and the next minute he's like, it's like he is not at all repeating what he put in his motion.
yeah. It sounds very, he's very chatty. And it seems like when they have a lot to say, they're kind of trying to, like, I don't know, explain it too well, maybe, or explain it. Oh, okay, here we go. Or I think, I don't know how they'll pop up.
I just don't understand how he says 1 minute, it's not about the money, but then he turns around and says he wants the money. I mean,
Rombo says, and that is not trial strategy. A mitigation specialist is not strategy. 'Tis being prepared for the inevitable. Well, get that too. Yeah. How many of you think, if you think that Chad Daybell is going to plead guilty, guilty, put a 1 in the chat. If you don't think he's going to plead, put a 2. If you think Chad sucks, put a 3. I know. What do you do? 1 or 3? 1 or 3. I'm just picking. I don't know.
Beach Bum says, what happened to the updating the court on all those monthly pretrial hearings? He's had a year. I mean, he's not showed his hand all year long that he was having these issues.
Hey, Mom. You're here? Oh, hey. Hey, Mom.
Hey, Kay.
I just want to cry. It's been rough, Mom. Water leaks, freaking murderers, and freaking health issues with Jason again. Right.
Hey, Kay. I'm trying to put Kresha and Jason on the spot about going to Kauai, Hawaii with Wayne and I. Maybe.
Only if I can say Kauai. I'm just being.
Well, I'm putting her on the spot about it now. I just encourage her if you think it's a good idea, Kay, that Kresha.
I want to go. What are you talking about? You ain't got to tell Kay or nothing. Shh.
Well, you didn't answer me, so
I haven't had a chance. Jason was sleeping. I was like, "Hey, KJ and Mr. Wayne want us to go to freaking Kauai." He was like, and then he fell back asleep. He's been asleep. I haven't had time to talk to him, but I don't have to. And I didn't want to. I wanted to tell you.
I
But
know.
since you put me on the spot, yes,
Well, here I am putting her on the spot, put
yeah.
pressure position, and she hates people pressuring her. Well, I've got
No, I'd rather that.
it was 8 below zero when I sent the text to you. I thought, sure, if she's cold too, the weather will talk her into going later on this summer.
Don't think I didn't sit there and think. I'm like, how long did Mom say that flight was? And I'm like, 10 hours. 10-hour flight. Oh, well, you can do it. I was like, you can freaking do it.
I've been to Hawaii before. It is a long flight, but it's very comfortable and it's well worth it. I
I
mean, it's
just
so
would
beautiful.
love to do that. I would love to go. I would love to go with y'all. Like, that would be.
We would make sure of it.
Well, crash of flying is a different situation. Uh-oh. What do you got to do? Get in a cargo? No, I'm joking. A cargo compartment or something? Look, I watched this video the other night. It was a man in Utah. I don't know if anybody has seen it. It was KUTV News. On New Year's Day, the Salt Lake City airport. Mom, we hate that airport. Anyways, so the guy is like, it looks like he's having a panic attack. And I know what those look like. I'm just like, oh yeah, she's like, they show him, coming in, checking his bags. He checked his bags with TSA. And then he just kind of freaked out, or I don't know what it was. So they just have him on different cameras all throughout the airport. He's trying to like open doors that are not ready. I mean, not open, and they won't open. And he's just kind of wigging out. And then he somehow he gets on the runway, and the plane that I guess he's supposed to catch. Okay. It's nighttime. And so they have him on whatever thermal camera, and he gets sucked up into the freaking engine. I mean, you don't see that part, but that's left for the imagination. Holy cow.
Well, I could see you and Jason finding a beach of your own in
Thank you.
Kauai and, ordering some malachite rings and, you know,
God.
we take all the pictures and then send them to Pocatello Women's Prison.
Oh my God. Oh my God. I like the way you're thinking.
It doesn't
Oh my God. I didn't think about
you're,
that, but that is
you're
awesome.
not ready for the legality of it. It could be just symbolic of your love.
Oh yeah. Just want her to be included.
I think everybody deserves to see real love, a real wedding on a beach and
Heat
not
and
some
sand.
serial killer
Mm-mm.
witchy and crap standing on the beach.
Oh my God. Can y'all imagine? If KJ saying when we go to Kauai, we'll go and have a ceremony there on the beach. We got to get married, right? 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 I mean, it's a perfect plan. And then go ahead and just send some pictures of me and Jason's wedding on the beach to Lolo over there in the prison. Oh my God.
That'll
That's
be so
beautiful. That's
special.
poetic.
Wouldn't it be special?
That's poetic justice right there.
Yeah, because she's never going to step her nasty ass foot out on that beach again.
No, and we won't send her any sand either.
The thought
Oh my God.
doesn't have to be legal. You don't have to have it legal. We could just do it for symbolic. You know how there's lots of couples
If
that
I'm gonna do it, we're gonna be doing it legal. I'm tired of playing with this. We've been together 5 years, over 5 years, it's time. I've wanted to, just haven't. I just not. It's a murder trial. Murders happen, not a murder trial. Murders happen. And I
Well,
mean, that just
if we do decide to do it and you're on board with it, it would be all expense paid for you and Jason. Y'all wouldn't have to worry about airline tickets or your accommodations or anything like that. So we're not getting any younger, Crusher K. Easton,
I know, ma'am. I see it all the time.
and
Well,
Wayne and I would most definitely want to give y'all space to spend time and explore the island yourself. And it would be
aw,
we'd be up y'all's butt all the time. We,
I think it would be fun, and it would be yeah, I think it would be a chance to make peace with that over there too.
yeah, you think they go over there and they do the evil, diabolical wedding
Mhm.
ceremony and lying and hiding from everybody. Man, we want to show them the flip side of that, and that's called love, trust, uh, just a brightness and a
Not
light.
murder, nothing dark, no hanky panky, no
Right.
extra lovers.
Just go and show what people really should be looking at instead of looking at their
No temples either. No temples either.
okay.
Sorry, that sprung in my mind there. I had to say it. Are they still recessing? Yeah, they are still recessing. It's crazy. Well, Mom says I know the perfect place. Uh-oh. We can get laid Hawaiian style.
We'll eat some of that pork that they put under the ground.
I love pork. Oh, couchon de lait is what we call it here. But yeah, it's a couchon de lait. That's what we call it here.
I forgot what they
Rotisserie.
call that. Where they
Uh,
put the pig underground in the coals and put those
a couchon de
fire
lait.
ants or whatever.
What else? I mean, I don't know what other people call it, but that's what we call it. Right, Mom? Mom, you want to come on? Y'all are welcome to come on anytime. Let me know. Yes, they do. Yes, they do. And so this is okay, but this makes me think about this. There, October 2019. Picture it. Okay. The Brandon done got shot at. Charles, Tylee, JJ, they were all dead. Melanie Pulowski has not met Ian Pulowski yet. They go to Hawaii, her, Audrey, and Lori. I've heard it through the grapevine. I mean, this is something I've said all the time, that it's something to do with Operation Underground Railroad. I need to start vetting it out. Okay. And so the word on the street, I'll just say, is, the speculation is that Melanie Pulowski allegedly donated $6,000 to Operation Underground Railroad. And I want to know if Operation Underground Railroad had some sort of event there, October of 2019. I want to know. I haven't seen any of that or heard it. I've just heard bits and pieces. It was from Carl Danger, who I heard that part about. But I've always known that, they would, Brandon and Melanie Pulowski would, or Brandon Boudreaux and Melanie Pulowski would, I guess run, in the little events and stuff that they would have to raise money. So did Joseph Murray. So did Emma Daybell Murray. Yeah. It's just, I want to know. I want to know. Another thing I want to do, I've looked high and low for 4 years. I want to know, where are flyers, if anybody can get your hands on them, screenshots, anything around Rexburg, September 22nd, 23rd weekend, whenever JJ was murdered. I'm saying that because that's why Melanie and David went to Rexburg for a firm expo, a firm show. I want proof. I haven't seen anything. Where is it at? Nothing with those dates, nothing in that place. Well, and I know it happened. And you want to know how I know? Let me go grab it real quick. Chad did a just let me know whenever they come back on. If they come back on. Oh, wrong one. Chad did a podcast with a Paul Pulsifier or Polis. I don't know how to say his freaking name. Who also lost his wife. Isn't that so crazy? So crazy. Real quick. All right, I'm in it. Let me find the screenshot. It is a screenshot from All right, let's see. Let me go back over there and I'm going to share my screen, and Donna, just holler at me whenever, okay? Because we don't ever stop looking. So, yeah, might be a court hearing. It'll come on. But we continue to look. We never stop. Because we don't. Here it is. All right, let me move all this so y'all can see better. All right. So this is Paul and Colette Pulsifer. Okay. September 8th, 2019. This was an awesome way to prepare for the Sabbath last night. So the 7th, this is the day, one of the days that Tylee could have been murdered. We don't know. Melanie, which he tags Melanie Gibb, and Lori gave me yet another helpful measuring stick. Measuring is key word there, to use in my efforts to purify my freaking heart. Okay. All right. This is from podomatic.com, but he shared it on his Facebook. And the hooker, Melanie Gibbs, says, "Thanks, Paul." So I don't know what the rest of this says. Oh, the rest of it, of his, this right here, the podomatic.com, feel the fire. Okay. I just don't like the language around this. It's disgusting. And I know better because I researched the hell out of this. Okay. Measuring. Jason Mao has a book about weight and measure or something like that. I don't know. I don't memorize every damn thing. But anyways, it says, following up on their first Feel the Fire podcast, Melanie and Lori share what their, quote, baptism of fire, unquote, was like, with insightful references that an ancient wise man, Nephi, that fucker Nephi, I said it, spoke about. How did it help Melanie in her own life with blah, blah, blah. I don't know. We don't know the rest of it. This is murder time. Okay. This is Tylee murder time. Thanks, Paul. Well, Chad Daybell appeared on Paul Pulsifer's podcast with him 2 days before my uncle was murdered. And the podcast was about patience. And it just makes you sick. It really does. Because the whole time they're plotting murder. Literally. Many murders. And it's gross. And it just it just goes without saying. But anyways, so this guy, he's lived in Canada. He's a little bit autistic. He's a little bit, whatever that other thing is. I don't know. I can't think of it right now, but it's like almost autistic. Anyways, which I think I am too, but it doesn't matter. But his wife died also. I've read her book just to see, I dig, I dig. I'm a digger. But yeah, thanks, Paul. This was an awesome way to prepare for the Sabbath last night. For Tylee last night? I'm just asking. Melanie and Lori gave me yet another helpful measuring stick to use in my efforts to purify my heart. I know what that means. I know what that means. You know what that means. We know what that means. So I don't know if these people, I know these people got Christ and the Lord and everything that encompasses backwards. It's upside down. It's wrong. It's opposite. So who is your Lord? That's a rhetorical question. It brings me right to Audrey Baratero when she was testifying, and I think it was what's his name? Archibald, that he was kind of out asking her questions. He was asking her questions, and she, he was like, "Were you praying to God?" And she was like, "I don't know," and basically, no, not the right God, not the right Lord. Anyways, because we know that because it's dark. It's dark. Everything they do is freaking dark. And so the scary thing is the public service announcement here. Alarm, hit all the alarms, bells, whistles. Okay. That's been my biggest thing right here is what about the rest of them? And then you have Tim, I was about to say Tim, a girl, Tim Ballard, you have Jody Hildebrandt, Ruby Frankie, and more. Just know that there's more. There's David Hamblin. There's David Levitt. There's Paul Hutchinson, Sean Reyes, Glenn Beck, David Barton. I just don't, Look, I mean, I'm doing this so I can look at some damn names. Michelle McDermott here. And I mean, I don't know if they know that they're praying to the wrong God or wrong Lord. You know what I mean? I don't know. Or if this is their understanding of it. Like, how backwards are we? I mean, it's pretty bad, I'd say. But there's a lot of people involved in this thinking. And that's scary to me. And it should be very scary for you too. And I know it is. I know that you guys get it. Let's see. I have I've been putting out this stuff about, Gordon Bowen, David Hamblin, Tom Harrison here. Gordon wrote the hit piece to Vice News that excommunicated Tim publicly. And then the church hired a new damn media person. And it's not because if they didn't agree with it, then they would have put out a statement saying, "Oh, we're sorry." They didn't. It's all with intention. Nothing's okay. And this is further proof. Here you go. I caught this and I was like, "What the frick? How did I not see this?" This was oh shit, I hit the wrong thing. This was a post, tweet or whatever from Adam Herbitz. This was Wednesday, January 3rd this year. Watch. Judge to determine whether evidence against Tim Ballard was actually stolen. One of the pieces of evidence has my face on it. One page includes allegations Catherine Ballard tampered with a witness via email by referring to her husband as, quote, the second iteration of Joseph Smith. Another page includes notes drafted by, you want to pay attention to this one. It's a doozy. Another page includes notes drafted by OUR attorneys stating a prosecutor told them Ballard had engaged in, quote, sexual affairs with 8 different women, all of whom were members of a group called Mormon Women with Blue Eyes, MWBE, unquote. What the frick? We know. I've seen it so many times with the blonde hair, blue eyes stuff, right? We've all seen it. We're like, what's up with the blonde hair and the blue eyes? You look at the Frankie children, blonde hair, blue eyes. Tim, blonde hair, blue eyes. Lori, blonde hair, blue eyes. This lady right here, Celeste, in the picture with her husband there, or ex-husband now, she doesn't have, I don't know what color her eyes are, but they don't look blue, and she's definitely not a blonde. But this is something. It made it in a freaking papers, court, legal.
Cresha.
Yeah, ready?
Your mom is, they're not doing it, but your mom said that she's seeing where they're going back into the courtroom. So that there must be going to be soon.
Okay.
So I'm just,
all right. Thank you. Cause I was just, yeah. All right. Let's see. Let's do aspect. Okay. I have it on already. All right. You put yours up if you want to, if you can. Mm-hmm. Thank you, Donna. A key point is where Boyce is in charge and has the law and process as appeal in hand with DP a certainty. You think so? I mean, Mark, do you think, I'm going to shut up. I'm going to shut up and hide us. Allegedly.
I was just refreshing it.
Oh. Hold on. Okay. So they weren't coming back up? Oh no, Trace, not another one.
Hey, Chris, I got a question.
Yeah.
with you talking about all this and everything, where does Janet Rousson fit in all this in terms of connecting with Chad Daybell and them and Jason Mount and all them?
Oh, I'll tell you in a minute. Yeah.
Krisha,
Yeah.
I refresh it every once in a while just to make sure that I'm
Oh.
catching it, and I'm scaring you every time I do that, and I'm sorry. So I'm
I'm just like, okay, it's time to go. Yeah. Okay, Janet Rousson, I mean, she's the quote unquote, she's a psychic. And she had the motherfucker. Oh, you're fresh, but I see people. So when they start talking, we'll shut up. All right. Okay, we'll shut up.
Thank you. Please be seated. All right, we're back on the record on case CR 22-21-16-23, State of Idaho versus Chad Daybell. This is a hearing on defense counsel's motion to withdraw. The court conducted a closed portion of the proceedings to make further inquiry, and then in addition, conducted an ex parte proceeding without the states present to inquire of the defendant regarding counsel. And with that concluded, now the defense has presented their argument in support of the motion. So at this time, the court will consider the objection from the state, noting that this was a shortened hearing, so the objection was filed yesterday, which I do find timely. I have read and considered the objection, and Ms. Blake, if you'd like to present argument in support of the objection, you can do that at this time.
Thank you, Your Honor. First of all, the state recognizes that this is a decision that is solely within the court's discretion. I think Idaho Criminal Rule 44.1 clearly outlines that. It does indicate that a motion to withdraw can be granted, or excuse me, may be granted by a court for good cause. The state also recognizes that the Sixth Amendment guarantees a defendant the right to counsel. There have been additional courts that have reviewed that and provided some additional interpretations, which includes a defendant's right to conflict-free counsel. The state is appreciative of the court conducting an inquiry today because case law also lays out that a trial court's failure to conduct an inquiry into any conflict may result in a reversal of a conviction down the road. Additionally, the onus is on an attorney seeking to withdraw to present sufficient facts to support the motion. And from the state's perspective, we are a little confused today because we read the affidavit that was presented to the court. Most of our motion was in response to that. The court has in fact done the inquiry and answered most of the questions the state had, also unsealing the order from the January proceeding where the defendant had referenced that Mr. Daybell was found indigent. We now have reviewed the transcript of that, and that did answer some of the state's additional questions, one being that there was an actual finding of indigency. The reason that that's so important in this case is because the Idaho criminal rules outline if someone is charged with a capital offense and they're found to be indigent, I think the term they use is needy, but the equivalent, and they choose to hire counsel, they're allowed to do that. They can have private counsel of their choosing. However, if they opt to request the court appoint counsel, then there's certain requirements, and that includes having a capital qualified first chair attorney and a capital qualified second chair attorney to assist them in the proceedings. In addition to that, it flags some additional requirements that the public defenders have to comply with. And there are quite a few of them in that list that must be complied with. But again, if a defendant opts to have private counsel, I think they do so knowing that their private counsel would not have to comply with those, or at least their counsel should be advising them of that. But they could also choose to forego having private counsel once they're found indigent in order to allow capital qualified attorneys to be appointed. In the review of the proceedings from back in January, it appears that there was a request to have some additional counsel assist on the case, and that was made by Mr. Pryor with his client, Mr. Daybell, present. At that juncture, it looks like Mr. Pryor was advised that if he could find someone else to assist in the case, that there may be funds available to help pay for that second attorney. In later proceedings, it looks like the court revisited that issue when no other attorney made an appearance. And at some point in those proceedings, Mr. Daybell was asked and essentially waived his right to have capital qualified attorneys. He opted to stick with Mr. Pryor. What's frustrating for the state is back in January a year ago, both the defendant and Mr. Pryor were aware of the defendant's financial situation. They clearly presented it to the court for the finding of indigency. At that juncture, they also were well aware that there was no second chair helping on this matter. So here we are a year later, and for the first time, this issue is being brought up that, hey, I actually want to withdraw because I'm not going to get paid. I'd have to work 24/7 in order to be prepared for trial and still probably can't get everything done in time for trial. So we've got two issues within that motion. One, the not getting paid, and the second one, whether or not Mr. Pryor can be prepared for trial. The state tries to be cautious in interjecting ourselves too much when it comes to a defendant and their choice of counsel. However, I think the ethical rules and other rules mandate that prosecutors try to ensure that defendants have the right or are advised and actually have counsel representing them in proceedings. When we look at that requirement of the state, as well as some of the other factors the state has to consider, such as appellate issues, the state tries to be cognizant of those and do our best to avoid creating them. I think that's what the court has indicated here today. The real question is, at least for the state, the finances the state's staying out of, but the real question for the state is, can Mr. Pryor be effective at trial? The state doesn't want to redo a trial. We don't want to get through trial and then have an appellate issue that requires us to do that again. While the state is extremely frustrated that this is being filed so late, and we are frustrated for the citizens, we're frustrated for the victims in this case. If this motion's granted, the state fully recognizes it's going to cause a pretty significant delay. And now the victims' families have to wait that much longer. The state now has to absorb additional costs. It's frustrating, but in looking at the big picture, we also want to ensure that we don't have counsel that cannot be adequately prepared for trial. When I said the state was a little confused today, the reason for that confusion is I'm referencing what was said in the motion. What's been presented here in court today is very different. So we have conflicting statements from defense counsel at this point. The motion read as if counsel was indicating, I cannot be effective. If you make me stay on this case, I cannot be effective. The reason I say that is no person can work 24/7 on something. We all have to have time to sleep. We have to have time to do other things. So I know it's a phrase used a lot, but the reality is if working 24/7, Mr. Pryor cannot be prepared for trial, what he's indicating is he would be ineffective at trial. What he's presented today is no, I can be effective. The motion says I'm not going to get paid. I want off the case. Today what's being presented is no, I'm fine not getting paid. I'll stay on the case. So if Mr. Pryor's representations today are I'm okay not getting paid and I can be effective, I don't actually know why we're here today. This doesn't appear to be a true motion to withdraw. The concern for the state is we've had multiple continuances in this case, and I recognize there can be arguments back and forth as to who did what and who caused the continuance. But at the end of the day, a year ago, Mr. Pryor was fighting very hard to get a continuance. He filed multiple motions to get a severance. He was finally successful with those in around January of last year. Maybe it was February, but he ended up getting both a severance and a continuance. Got a year-long continuance. Again, last January, Mr. Daybell had been found indigent. They knew there wasn't a second chair. He's proceeded on the case for a year. He had the benefit of watching the co-defendant's trial. He knew exactly how long that trial was, was able to observe and see how many witnesses there were, should have had a very good idea of what the trial preparation was going to require at that juncture. So again, very frustrated that we're getting here, but we had that. The request was, I need a continuance to test the DNA. We get past the trial. I'm actually not going to test the DNA. The state recognizes that different tactical decisions can be made, but it was very frustrating that we ended up with a continuance and severance for something that never ended up getting tested. Now here we are again, a couple months. I think today is actually 2 months before we're supposed to start some trial proceedings. And we're hearing a motion again on a request to withdraw where the representations today differ significantly from what was put in the affidavit in motion. So this does appear to be another attempt to simply get a continuance. So the state's position on this would be based on the representations today. It doesn't appear this is a motion to withdraw. And if Mr. Pryor's representations today are accurate, then I think the motion should be denied. The one question the state has that has not been answered directly to the state, and maybe the court has this information, is there were some conflicting things also represented about Mr. Daybell and his specific position on this. In the affidavit, it indicated he did not want Mr. Pryor to remain on the case, that he wanted to have capital qualified attorneys appointed, that he didn't feel it was fair Mr. Pryor wasn't getting paid. Today, at least from the state's understanding, is we're hearing that Mr. Daybell does in fact want Mr. Pryor to get paid, so he wants him off the case. But then we're also hearing that Mr. Daybell would like Mr. Pryor to stay on the case. And I think that's really the important question today for the state is, does Mr. Daybell in fact want Mr. Pryor removed from the case? He's hired as private counsel. Is he in fact requesting Mr. Pryor be removed to have capital qualified counsel appointed? Because I think that's a different analysis and a different scenario than an attorney asking to be removed. So the state does not know the answer to that. I think we've.
Ms. Blake, I want to be careful because I had an ex parte proceeding, but in general terms, I think it's appropriate for me to advise the state that Mr. Daybell does desire to have Mr. Pryor continue in the case. And as you mentioned, is also very concerned and does not want him obligated to essentially work for free. So that's his overall position in general terms.
And I think that's where we kind of run into an issue. While he may not want him to work for free, Mr. Pryor was hired privately. If a person has the resources to hire private counsel, or if a private attorney decides to stay on pro bono, I think that's the counsel and the defendant's choice. I don't think there's any avenue to allow Mr. Pryor to be paid through another mechanism. I also don't think there's a mechanism that allows a public defender to be appointed to assist Mr. Pryor. I think under the statute, it's if you're indigent and you're asking for counsel, you get a first chair and a second chair qualified appointed. I don't think under the statutes and the criminal rules, I don't see any hybrid system allowed. So I guess the state's concern is if that's the position of both the defendant and counsel, then we should simply be proceeding to trial and this motion should be denied. It's not a true motion to withdraw. If Mr. Pryor is saying I can't be prepared for trial in April, the state's very frustrated that this is clearly just a veiled motion to continue with a different title attached to it. Because that appears to be the true argument today is I need more time. So the state's very frustrated with that. Mr. Pryor's already had a year continuance. I guess from the state's perspective, if Mr. Pryor is going to stay on, we're headed to trial in April. The state's ready to move forward. If Mr. Pryor is saying I can't be effective at that point, then I think capital qualified counsel should be appointed and we should move forward with that counsel appointed and selecting a new trial date. But I don't think Mr. Pryor should be granted a continuance if that's really what's being sought today, and that's what it truly sounds like is being requested.
All right, thank you for the argument and response, Ms.
Judge,
Blake.
could I respond briefly?
I was going to allow you a response, Mr. Pryor, so go ahead.
Judge, I don't think I've been inconsistent in my representations in my declaration and what was said today. This court took the time to inquire of Mr. Daybell, and I believe what Mr. Daybell related to the court is consistent with what was put in the declaration. The reality of it is that I disagree with counsel, and I don't know what she's reading or how she's interpreting a statute, but this court entered an order allowing the assistance of a second counsel to help in the preparation of this case, and did it some time ago. The reality, Judge, is that although I've made a strong and diligent effort to find co-counsel to help me in this, it's been difficult, and I haven't been able to accomplish that. And the reality is Mr. Daybell recognizes where we are in this thing and what needs to be done in the future. I don't have the benefit of Fremont and Madison County with their 5 attorneys in their prosecutor's office having free reign to do what they want at government expense. And the fact that both of those prosecutors then, in addition to their 5 state attorneys, sought out an attorney from Missouri and at county expense and on the county dime brought an attorney to work on a case that wasn't a death penalty case for the taxpayers of Fremont and Madison County to pay for that attorney, even though it wasn't a death penalty case. And that attorney is still on and still going in this case. And they've expended a significant amount of money, and I suspect it's not at the hourly rate that a prosecuting attorney makes in Fremont and Madison County. I suspect it's significantly higher. And for me to suggest that it's difficult with their 6 attorneys that they're working on this case, and I have to do this by myself, and the court recognized
Right,
the
you've been on a
workload.
case for 2.5 years by yourself, and
I have.
all these attorneys, and the state carries the burden at trial, and they can prosecute a case they want. I completely agree with the state's position. The timing here, 2 months before trial is going to start, none of this is new at all. The charges have not changed since the indictment. The co-defendant went through an entire trial, which you observed and knew how long it would take. We talked about this concern a year ago, and here we are on the doorstep of trial, essentially. And the argument that is not persuasive at all to me is you're just learning now how much work it's going to take. Experienced attorneys, which you are, you figure out how long cases are going to take, and you pick and choose the cases you decide to take as a private attorney. And this argument that they have more attorneys than you, they do. That's what they've elected to do. And you've also elected voluntarily, as has Mr. Daybell, to come on this case and represent him. And you've represented him since the beginning, and in fact, even since before this case began.
And Judge, the issue also is that I per my representation earlier, is that in 2022, I started seeking out assistance and additional counsel. And I made a diligent effort. In fact, I took the extra step of seeking counsel who were death penalty qualified out of the state, out-of-state attorneys. I then tried to find attorneys on the Public Defender Commission list and made a diligent effort. And then when I found one, I believe in October of last year, my expectation is that he would have been on this case by now. But then we come into late December and I'm finding out that he hasn't been approved or put on the list, even though the court authorized the funds, and I'm in this position. As I've said before, Judge, it's not a matter of being ineffective. And for the prosecutor to sort of hint at the fact that I've been ineffective, I would remind the prosecuting attorney that the fact is that, and I don't want to rehash this, but any continuance was the result of them not turning over a lot of evidence, and a lot of evidence that I ended up having to go through and make a determination. So they can't put any continuance on me when it was their own issue in terms of the discovery. The other issues, Judge, are simply this, is that having made that effort to find these attorneys and help me with this case, I recognized that back in 2022. But being able to find someone is a whole different story. And the reality of it is this, is that I'm not making differing statements from what I said today and what I put in that declaration. I've spent a portion of my life representing Mr. Daybell, and I would like to have continued that. But he sees the effort that needs to be go forward. And my expectation was in December or November of last year, I would have had an attorney on by now to assist me in this, and that hasn't taken place. And under our current law and the way the law is written and the way the court has interpreted the law, the only way for me to get another attorney and to have Mr. Daybell have the 2 attorneys that he wants, and what it was said in that declaration and what is said today is still consistent. The only way to do that is for me to make the decision to step away from this thing. And to step away from this thing would guarantee and require Mr. Daybell to have 2 additional attorneys. Is it something I enjoy or want to do? No. Mr. Daybell knows full aware how I feel about this case and how I wanted to be involved in this case. There has not been any differing representations to this court. The problem is this, and I recognized, you know what, they get to gauge how many attorneys they want. They get to gauge the amount of money they spend. And in terms of getting assistance for a defendant, I'm bound by the rules and the way the rules are written by our state legislature, and I'm bound by the statutes. And being bound by those statutes, I have no choice. If Mr. Daybell's going to, get the trial that he deserves, either I find someone to help me, which I did starting with this court in January, but well before that, and to no avail, or I have to make the difficult choice. And I understand it's 2 months before this trial. I understand that. And it's not a choice I want to make. It's not a decision that I want to make in this case. But that overriding want for me to stay on this case, or that need for me to stay on this case, is overridden by the fact that Mr. Daybell should get 2 attorneys to help him with this. I would have liked to have been one of those, but there's no mechanism to do that. So any suggestion that I've been ineffective is ridiculous. This case was severed. This case was transferred to Ada County, and Mr. Daybell would agree with me that I've done everything to strongly and effectively represent him in this case, and he is completely satisfied with what I've done. But there needs to be additional help. And unfortunately, under our current statutes, I don't get that if I remain on this case.
And Your Honor, I just wanted to clarify one thing so we have a clear record.
Go ahead.
The state has in no way insinuated or represented that we believe Mr. Pryor has been ineffective. What we were referencing is based on the affidavit written to the court that we felt that was what was being indicated, is if forced to proceed to trial, he would be ineffective because he simply didn't have adequate time to finish his preparations for trial. So I want to make very clear, we are not saying Mr. Pryor was ineffective. I want that very clear for the record.
I understand that, Ms. Blake, and I agree. The arguments have not been any ineffective assistance of counsel. The arguments have been related more towards going forward in the demands of a 2+ month trial, and whether, given the concerns raised by the defense, a single attorney, that being Mr. Pryor, would be capable of providing all of the defense necessary for Mr. Daybell in this case. So that will conclude submission of argument on the motion. I'm going to take a brief recess, review a few things, and then I'll come back on the record to make a ruling on your motion shortly.
All right.
Well, okay. Oh, shut up. Look at him. I'll beat his ass. I just want to whip him, just real good. Whip him. All of them, in the whole damn courtroom. Right? Oh my God, she was hitting some points though, but you know. Hey KJ, I'm trying to unmute you, but I can't. Oh, add to stage. How did that happen? Okay. You're gonna have to unmute yourself though. I added you. See?
I'm here.
I know yeah. I don't know why you kept popping in and out. Every time you'd pop in, we'd go back on the screen. I was like, well, wait. Anyways, what's up? What you got?
The only thing that I get out of it all is that Pryor wants help. He should have been asking for this help a long time ago. To say that, oh, I approached somebody back in October and they didn't get certified and all this and that. He absolutely does not want to withdraw. He wants to stay on the case, but they're at a place now where
Point of no return, right?
right. I mean, they just now said this had nothing to do with ineffective assistance of counsel. I don't know what part of what he's had all this information for what, excuse
Bless
me,
you. Bless
2
you.
years, at least 2 years. I don't understand what he's been doing all this time. He got a dry run when he saw Lori's. I'm kind of confused about what he actually is asking for. He's asking for help and money, or he is not asking for help and money. He wants to go ahead and get 2 other qualified people on, certified people on there. And the question is would he be part of that team?
Mom says, so proud judge is making decision today. Pryor is whining as usual. He had time to sit in her case for 6 weeks. I saw him with my own 2 eyes.
Well, the only good news I see is this cannot be deemed in a court of law as ineffective assistance.
Right. Because Chad's still wanting him. The state is saying we're not saying he's ineffective. Pryor wants to be on, right? I'm just kind of laying that out. I got to make it in my mind. right?
So what are our what is his
I think just me and my uneducated, I don't know, but I think he's gonna make him stay. I don't know about the pay. They can work that out. It's above my pay grade. Obviously, it's above his too, but they can work those kinks out. That'll keep everything rolling. If not, then it's
well,
gonna
look, this
cost even more money.
situation when you have somebody say who's being charged with something, right?
Yeah.
Um, and they're indigent on anything, car crash, robbery, whatever, and they're indigent, they get assigned a public defender.
Mhm.
Well, he could be Chad's public defender, right?
Right.
But the big problem with it all is
It's
it's
the
not
big
just,
DP.
it's a death penalty case.
It's a conundrum. It's a catch-22.
So John Pryor does deserve to be there, and John Pryor should get money from the state if he is his public
I
defender.
agree. I agree. I think we all agree on that. I mean, you
But
shouldn't.
so if that's the case, and if that's the fact that if John Pryor is seating himself as his public defender, and yet they're wanting to throw in the mix of two certified lawyers for the death penalty, where does that leave John Pryor? Can he still be on there?
I would think so, because I remember this happening with Mark Means when all that happened, and they were saying how Mark Means, and I mean, I say they, I'm just talking about the court of public opinion, and how people were saying that he would be the second chair because he knows the case. Pryor
Well, okay,
knows the case.
let's just say for argument that they hunt down two certified death penalty attorneys, and John Pryor is on this team who knows a lot of all this stuff. That's three attorneys right there. Is that
Mhm.
not enough to get them ready for April 1st if there's three of them?
And John Pryor even said he's asking for 2, but at least 1 other death penalty qualified. I mean, I pulled up the roster 2 live streams ago, and I didn't know how to tell who's left out of, because I mean, this was back when this all happened with Lori. They assigned her 2 death penalty certified. That was Thomas and Archibald. Well, that left Ann Thomas and another death penalty qualified. I don't know. I know that Ann Taylor went to Coburger. I don't know if that leaves 1 or if the last 2 are, on. So I don't know if there are any available. I'm sure things have been adjudicated since then. Maybe there's 1 free. Maybe they should stop doing some heinous shit over there. I don't know.
Well,
Just
when
saying.
they severed the cases between Chad and Lori, and her death penalty status came off the table, that's when those 2 death penalty attorneys, Archie and Thomas, should have walked away from there, because they wouldn't be representing a woman would only be representing a woman who is not going to get death penalty trial. But they stayed on with her.
Well, I mean, that was at the very end too. That was at the very end. That really sucked. That whole, we're going to punish you by taking away the death penalty prosecution. You should turn it in 10 minutes earlier. Oh, I just feel like I don't know. I really don't care about how they do their shit, as long as they just do it and stop fudging it up all the way. Okay?
Well, the way that Lindsay Blake is speaking and everything, she is like, I mean, I'm just parsing words here, but she's like, there's nothing that says that this can't move forward. She's making that argument, this isn't about ineffective assistance of counsel, and that means that if there's nothing ineffective about it, then you should be just continuing doing your job. He's needing another
person on his team.
I'll put them on there. Let's go.
He's already got a mitigation specialist,
Allegedly.
and
So
he,
he says.
no, they're not just trying to find out about, let me give you an example. They get through to Chad getting convicted, and then they have to go into the second phase. The mitigation specialist has gotten all the stuff together from Chad's childhood on all the way up. And obviously, you're going to know it, y'all. Chad Daybell's never broke the law. Chad Daybell's never done anything.
No, he was saving it all in his little,
His mitigation, the mitigation is going to look really good on him, but it didn't look good on Lori because she had been in trouble in the past. So
Look, Ian Austin, he asked, I have a question. If Pryor is allowed to continue, is there going to be the opportunity to declare a mistrial? Sorry for my English. Hope you understand. You did perfect.
say it one.
How would it be a mistrial? I have it on here too, if you can read it. I have if Pryor is allowed to continue, is there going to be the opportunity to declare a mistrial? I don't think for that.
No.
I don't know. I'm not a attorney.
It wouldn't just be John Pryor saying, okay, I'm going to stay on. No, the judge makes the final decision through judicial.
So that way it could be an appeals though, right? I could see that happening. Am I uneducated? And
the subject of whether John Pryor should stay on or not.
If John Pryor stays on. If
you're saying it could be an appeals issue.
I think so. Maybe.
Well, I guarantee you
but then maybe it couldn't because Chad is like, yeah, I want him, but he also wants, but hey, we want our family members alive. Guess what?
I can tell you this when it comes to running up against the possibility, the possibilities of some kind of wrongness happening in it all that turn into appeals issues. I guarantee you Judge Boyce is sharp. He knows what is going to fly and what isn't. He's the neutral arbiter. He's going to do everything he can. First and foremost, his whole thing is that the defendant gets his fair trial and his rights. And then also the state has their case in chief, and those things kind of mesh together, and what comes out of it is really what the judge is going to base his decision on. So is the judge going to base his decision on, well, I've looked at all this and I've heard from both sides and everything, and we're just going to start over. Chad, you're going to get 2 certified attorneys. John Pryor, you can withdraw. And, any kind of interesting things about wanting to get paid or this or that, you can go over to the administrative building and talk to them about it. Judge Boyce is going to make it to where that it's going to go. I just have a really strong feeling that he is going to go with this new team.
Just to kind of wipe the slate and just let's roll with it for future.
But I don't think he's going to make it go on forever. I don't think I think he's going to give them a few more months to get up to speed on it.
I love your picture behind you. It's beautiful, by the way.
Do what?
Your photo or whatever that is behind you. It's beautiful. Your background.
Oh, yeah.
It's gorgeous. Okay, I see now. It's not a painting. It's I remember those carpet rug things, or I don't know, a tapestry, I guess you would call it. It's beautiful.
It's called my blue room.
It's beautiful. It's beautiful. There
I
you
wish
go.
I could be as beautiful as the colors on that wall.
You are. You
No,
are. I couldn't
I'm
see them because you're so beautiful.
creepy, creepy robe.
Yeah, you sound like you're getting sick. I was sneezing too, like all yeah. Are you getting
All
sick?
day yesterday, I was snotting there, lot left and right. And I took me an antihistamine, and that's helped a little.
Well, good. Mucinex. That's what I take.
So what goes on here? Are they fixing to let us know what's the answer?
Not yet. Oh, I can see it backstage. Donna, I can see whenever she refreshes it and everything, and nothing yet. They're still deciding.
Well, some seem to think that the state is going to give John Pryor money and an extra attorney, and then he ain't going to have no excuses.
Right. Yeah, I mean, I can see that way too. We could always go Jason's way.
What's Jason's way?
The most expensive way I ever heard, but he has a point. The one he proposed. He was being serious too. He was like, just they could drop the charges with prejudice or without prejudice for Tammy with Chad. Go ahead and just, go, because it wouldn't be death penalty for the kids, for the conspiracy. Go on with the trial. And he was like, once he's convicted, then ream his ass for the death penalty. Would, come back with a round 2 for Tammy. And I'm just like, that's a lot of money and a lot of time.
Conspiracy to commit murder on those kids is the same as first degree
But
murder.
that's not my understanding is, and I thought it was just for all of it, but no, it is for Tammy. I mean, that's where that's what I got from it. From the beginning. First degree murder, with the financial crimes on top of that. I was listening to his whenever he appeared for the first time with John Pryor. And he giggled. That's when he was like, and I was like, oh my God. And the way that, what's his name? Judge Edens read it to him, it sounded like it was like Tammy. You know what I mean? Like, that's the vibe I'm picking up. I don't know. It's more for the cold and callousness. I don't know. Probably for all of it, the totality of it is horrible. I mean, you can't wrap your mind around it, but really, Chad was way okay. He was fine. He made peace with it. To allegedly murder his wife, bury her, and flaunt his new bimbo in front of his people and his kids, his grandkids, the whole damn temples, all the temple visits.
Wonder how many
Insane.
spouses are murder, Mormon spouses are murdering their.
Tom Harrison's wife died. That guy I was telling you about, showed y'all earlier, Paul Pulsifer, whatever his name is, I can't think of it right now. His wife died. And Tom Harrison's wife, she died because there was a mission. He had a mission to fulfill. I don't have enough time. I don't have enough gigabytes of storage in the cloud. Or I'm telling you, it would blow up the damn system, the damn internet. It's not funny. It's just like that. And the Tim talk about Catherine and the poison in the cookies. And I mean, it doesn't matter. They'll just issue you a new one. That's what it feels like to me. That's what it looks like to me too. With all the LDS, which my Uncle Charles used, the dating apps. That's how Ian and Melanie allegedly met. That's how Charles, he was on LDS singles, whatever. I looked in AVAL on, their site and everything many times, but they promote that, and they say to find like-minded people. They embrace that like-minded people.
let me just say this: if
It's
John Pryor,
scary.
if John Pryor gets off of this case, he can withdraw from this case. At this 11th hour or whatever, many defense attorneys will start doing this. This will set up a precedent. It's a strategy that is shitty. It should not be happening. He has not given anyone any hint that he wasn't handling his shit. He even said he was ready on several
But he's,
occasions.
yeah, and he's at Lori's trial. I mean, that's somebody that screamed confidence, like, I got this, you know? That's what it looked like to me. Like, you're here, but you have a trial to prepare for. He used the children's bodies, him and Chad, him and or Chad. Either way, he used the victims' own bodies as I want to say a pawn, and you know, here, another pawn piece, another pawn. Those kids were pawns their whole lives. And then Pryor did it just to get, it's like once he got the trial severed, the case is severed. Oh, here, let me sign off on those. So, I mean, he said he was going to be doing DNA testing and everything, and he did not do any DNA testing.
He didn't do any of it. He drug out.
Ooh, that pisses me off.
Whole purpose was to get the cases severed. I told y'all a while back he'll never do any of it. He didn't have the money to have it all tested.
Right. And it's so, but hindsight, you're like, yeah, okay, confirmed. That's what you did. You used them one more time. That there should be a law against that shit too. You know, really. Oh, I gotta get like some schooling done and get in some lawmaker positions and learn how to talk. I gotta start repping or something somewhere.
I will confess this. I want to see John Pryor on this trial
I do too. You're not confessing anything that I don't want myself.
because I know that he will not be Archie and Thomas.
Right. He's gonna push and he's not LDS. Nor he doesn't seem really scared to tiptoe through the lilies. And you can't be, it just, you have to respect it. But I'm sure, being an Idahoan, there are many non-Mormons who have to live with Mormons and the way that business is conducted. And it is a theocracy. End of story. It is. I didn't do it. You didn't do it. That's how it's done, though. Utah, Idaho, I pray to God Arizona no. I pray to God. They seem a little more, they're just, people are put into these different positions. We see it in the Hamblin case. Holy hell. David Levitt, Sean Reyes. You just, I got friends in low places. Well, and then Beach Bum had brought this up in our group chat. And I was like, oh, I can't wait to get my teeth into that when we get off of here. She wanted to know, could they, with all of the businesses the LDS is involved with, which is damn near every damn thing, could they actually own the prisons, jails in Utah and Idaho? Now I know for sure that they do own. There's LDS abuse. You have big news? I have big news to show how it's a theocracy. Miss Kresha, call me when you can. Oh my God, I will. You're such a big help. God, y'all follow this guy on X. He's a good Mormon. He's a good Mormon. There are good Mormons. We believe in them. Right. But so the Mormons do own some of the mental hospitals and facilities and things like that. But anyways, but Beach Bum was like, many jails are privatized and kickbacks go to the government from the phone calls, commissary, prison clothes, etc. It got to bugging me about being residents / inmates on Idaho prisons. Why? Then they control politics, policies, lobbyists, businesses, big and small. Girl, I was like, I didn't get this far. And I was like, why did I never think about that? Just to research. It's just the more you know. There's nothing wrong with learning and doing your own research. Okay, I think they're coming back. Okay, we're gonna hide. Oh, I've been one, damn it, dolls.
All right, I confirm the live stream's begun again. We are back on the record on case CR 2221-1623. The court has before it the defendant's counsel's motion to withdraw filed on January 11th. I've considered the motion along with the declaration in support of the motion. I've also considered the objection from the state. We conducted a hearing today where I heard argument from the counsel, Mr. Pryor, in support of the motion, the objection by Ms. Blake from the state. Also conducted a closed portion of proceedings and an ex parte inquiry of Mr. Daybell and Mr. Pryor. And I've taken all that into consideration in determining the ruling on the motion. The court first is governed by Idaho Criminal Rule 44.1, which under paragraph A talks about leave to withdraw. And I'll just quote that section. No attorney may withdraw as an attorney of record for any defendant in any criminal action without first obtaining leave and order of the court on notice to the prosecuting attorney and the defendant, except as provided in this rule. Leave to withdraw as the attorney of record for a defendant may be granted by the court for good cause. So we've gone through the procedural steps to get here for this to be properly considered. The rule allows the court discretion where it indicates the court may allow for withdrawal, and then looking at the standard of for good cause. So the court will first note to clarify in this case, this is a capital case. Idaho does have a separate rule governing the appointment of attorneys who are on a roster that are considered qualified to represent counsel or represent defendants in capital cases. That's Criminal Rule 44.3. And importantly, that rule only applies when a defendant is represented by a public defender appointed by the court and does not apply when a private attorney is retained in the case. And also importantly, where the court made reference earlier to questions about the mitigation phase, if that were to occur in this case under Idaho Code 19-2515, an inquiry to Mr. Pryor. And I'll note, and Mr. Pryor has correctly pointed out, that the ABA guidelines do apply to public defenders. They are not necessarily required to be followed by private counsel. Private counsel under Idaho rules are allowed to take on a case, capital case, and those guidelines may or may not be elected to be followed by a private attorney. Mr. Pryor clearly is a private attorney in this case, has never been appointed or publicly paid for representation of Mr. Daybell. Mr. Daybell importantly does have the right under the Sixth Amendment of the Constitution to counsel, and included in that right is to have the counsel of his choice. And Mr. Daybell elected a very long time ago to have Mr. Pryor represent him in this case. In fact, Mr. Pryor has agreed to take the case and has represented Mr. Daybell not only through the initial stages of the case here where the indictment was returned, but also in a previous companion case, and for I think about 3.5 years now, has represented Mr. Daybell. The court then going back to consideration of the motion before the court. There's an issue here that's been raised by the state about the timing, and of course the court joins in that concern also. Mr. Daybell has been incarcerated since June 9th, 2020. We've got a trial scheduled in 2 months. Mr. Daybell's asserted his right to that trial, and although he has waived his right to a speedy trial, certainly this case has taken a long time to get to trial, and at some point, even with a waiver of speedy trial, the court has to consider the timeliness of a defendant in custody being granted their opportunity for a timely trial. That right also applies to the state, and the state's right to seek justice for victims, to seek a conviction if they believe they have the evidence to do that, and to not have to wait through unnecessary and unreasonable delays in bringing a case to trial. So the court has a duty to try to timely administer cases, and while the rules generally slow things down a lot, there are reasons for that, but at some point the court has to consider the timing here. That's the big issue with this motion, quite frankly, is that the motion, if granted, would absolutely require a continuance of the trial and not just a brief continuance, because what would occur if I grant this motion and Mr. Pryor withdraws from the case, then under Criminal Rule 44.3, the court is required to appoint 2 capital qualified public defenders, absent Mr. Daybell having some manner of, again, rehiring a private new attorney or getting one to do it pro bono. The issue there is Idaho has a sparse number of attorneys on that roster, and Idaho is currently experiencing a lot of cases that are already resulting in appointments of a lot of available attorneys. And quite frankly, I don't have any idea who would be appointed of the 2. I don't have any idea when we could get them appointed. But what I do know is the trial would have to be vacated and would have to be continued, and I think likely for a long time, maybe a year, maybe even more. Because for new counsel to come in, start over from scratch on a complex case like this, not have any review of discovery or any preparation, they would have to reasonably request time to get prepared, which would have to be granted. Mr. Pryor was raising concerns about trying to get second counsel appointed, and I've tried to accommodate that, Mr. Pryor. We had a hearing, it was exactly a year ago, on January 19th of 2023, and talked about your concern. The way I interpreted Rule 44.3, while it doesn't really address a situation with a private attorney together with a public defender, I don't think the rule necessarily prohibits that either. And so I approved that you could have co-counsel if you could find someone, but of course, they would have to be on that approved roster because this is a capital case. I don't doubt that you've made a diligent effort to try to find co-counsel. That's clear to the court. I know we've addressed that over the course of the last year on numerous occasions, the status of whether or not someone was coming into the case. We're on the eve of trial and no one has come into the case. With that in mind, then, the court has to also look at the impact that could potentially have. If Mr. Pryor withdraws from the case, Mr. Daybell is required to start over, abandon an attorney-client relationship that's been ongoing for several years, start over with a brand new attorney-client relationship with someone that he doesn't know and we can't even tell him who that would be. And also with the delay, I find that that prejudices the defendant. I also would find that given all of the preparation and time that has gone into this trial setting, which has been scheduled out for a long time, made by both the court and obviously the state in being prepared and ready to go, that there should be a presumption that we maintain the trial date. So the 2 concerns here raised in the motion really are, number 1, the fact that Mr. Pryor would not be able to obtain payment for his services. And the court does strongly consider that because attorneys work for their profession and it's important that they get paid, and it's a consideration. But that in and of itself does not, in my mind, rise to the level of good cause under the rule 44.1 to grant the withdrawal. The second, and I think more concerning issue, is some indication in the motion of Mr. Pryor indicating that it would be very difficult, if not impossible, to be adequately prepared for trial. That's what's set forth in the motion. However, upon argument here today also, Mr. Pryor has indicated that he has made steps. I don't find anything in the record that he's been ineffective in his assistance of Mr. Daybell's defense in the case. And so with the concerns today being brought up and addressed directly by the court, both in open and closed proceedings, I don't find any specific grounds indicating that Mr. Pryor has said he cannot and would not be ready and prepared to adequately defend his client. Although it may be difficult and he apparently will not be able to be compensated, it's not in the record that it can't be done. And importantly also, Mr. Daybell has affirmed today he does intend and would like to keep Mr. Pryor as his attorney in this case. And finally, I'll note that in addressing these concerns at that hearing a year ago, there was a representation by Mr. Pryor who said directly to this court, and I'll quote what was said in the hearing, quote, "There's going to be no continuance because I'm asking to get out of this case. That will not happen." And the courts relied all along on those representations in getting this case scheduled. So in balancing all that out and looking at whether or not good cause has been demonstrated today, I do not find that there is good cause for withdrawal of counsel. And so under Criminal Rule 44.1, upon consideration of that standard, the court is going to deny your motion to withdraw Mr. Pryor. I will note that I've previously made an approval for a second chair. If one can and will join the case, then the court will permit that and we'll go through the procedure to get that properly done. So that's not a foregone conclusion. Given the timeliness of the trial, I understand that may be difficult. However, we are where we are with this trial setting, and because of the proximity of trial and the necessity of a continuance, if this motion were granted, the court finds that the motion fails to demonstrate good cause under the rule. For that reason, the motion is going to be denied. And Mr. Pryor, you will continue to represent Mr. Daybell through these proceedings. That'll be the ruling on the motion today. And I'll note that we do have more hearings scheduled and coming up, including motions and a pretrial conference. So, Mr. Pryor, do you have any questions on my ruling?
No, Judge, thank you for your consideration.
All right, thank you. Ms. Blake, any questions on the court's ruling? All right, thanks everyone for your attendance. That will conclude today's proceedings. We'll be in recess.
All right. Whoa. Okay, hold on. Okay, I don't know how to work this thing. It's my first day. I'm trying, KJ.
Well, it's obvious that John Pryor's motion to withdraw just blew up in his face.
Yay.
Judge Boyce wants him to stay on. He also said that he was going to work with John Pryor to find him another person to help him. So I wasn't quite clear about the money aspect, but he's not going to let him off the hook.
Okay, you keep talking. I gotta go fix my light.
and this also means that there's not going to be a continuance. So that equals into this is staying on track for April 1st.
All right. That's good. That's good, right?
That's great.
That's great.
And trust you me, Judge Boyce has to look at all aspects of, well, could this motion that I denied of John Pryor, could this get
He's weighing it.
litigated in an appeals court or anything? Judge Boyce is not going to do anything that is going to be an appeals issue.
Oh, right. Mom says, woohoo.
So this is moving forward.
That's good.
I mean, right now it's moving forward. I don't know what else John Pryor is going to pull out his ass, but it ended up being better than what we all thought.
Yeah, I didn't consider this, but I mean, he's staying on the case. It's kind of one of the last things I did. It was down on the totem pole.
I mean, Judge Boyce just said, you've been on this case for 3 years. It ain't like he's handicapped or anything. Yes, he could use a second chair or something, and they're going to try to get him somebody in there to help him. So
Hey,
it's
Moonlight.
going to go. It's going better than we all expected.
Yeah, everybody's happy. Everybody in chat is happy. Happy, happy, joy, joy, right? No more delays. He still will ask for more time, I'm afraid. Carla
Trace on
says.
the case says, woo!
Yeah.
Mohawk Mom says, what the other hearings, I wonder what the other hearings are about.
No, we don't have any lawyers to help us. We are not lawyers. We are just winging it like we do everything else. LDS abuse. Are you a lawyer? Want to come up? You're welcome to come up anytime.
Liza Joe says Pryor has ineffective counsel on the record now, though. No, because Liza Joe, just as the state and the judge said, there was no determination of ineffective assistance of counsel. They made that clear. So that is not something that, I mean, obviously, why would the judge keep him on if there was ineffective assistance of counsel?
Right.
So the state made it clear. The judge used
Chad
those
makes it clear.
words. There is no ineffective assistance of counsel. You top it all off. If it was so ineffective, why does Chad Daybell want to keep him?
Mom says, aren't there more motions to be heard today? I think at the very end he said, I don't know. I can't ever quote anybody. I suck at that. Something about pretrial hearings. Mm-hmm. Wasn't today. It was not today, obviously. But I mean, what told me a lot was whenever Pryor filed this motion to withdraw, and he wanted the trial, the hearing date was supposed to be January 30th, but the court was like, no. And they went ahead and scheduled it January 18th, which is today. And that to me gave me my first inkling of how the court is approaching this, and it was to get ahead of it and
When I read his motion to withdraw, there was never once the statement made in there, ineffective assistance of counsel.
it was just the death penalty.
All he talked about was that there was 5 attorneys on the other side and all this and that. He never said he was ineffective.
Yeah.
He never used those words.
Lisa Hayes says Judge Boyce has to keep a neutral face, but he saw what was done to those kids. He is beyond sick of the shit, I think. I like the way you think. I think we all saw it in Judge Boyce's face, which was surprising because he's usually just he don't have poker face. But I saw how every time Lori would speak at her allocution, I mean, he was just like, he scribbled a damn book. I'd love to see his notepad for that day. Whatever he was writing on is what I wanted to see because anyways, and yeah, you could tell he was disgusted. And just, yeah, the whole community, just everybody, we all need to heal, damn it. But again, I'm going to say this because this is something that I've noticed is like the state, and I'm just telling you how it feels. Like this is not throwing shit at nobody. But it seems like the state wants to use the victims when it's convenient. and by the victims, whichever, either the ones that were murdered or the family members and friends and family who are left, to shoulder the burden. And, I've heard them say before that, we're not here to represent the living victims. We're here. I'm just saying I heard when Lindsay said something about, this is it was kind of like a shaming, a public shaming, saying how the living, the victims will have to endure this. It's more hard on them. I don't know what she said exactly, but something to the tune of that. And I was like, okay, you don't get to speak up. You can't. I hate double speak. I hate it, turns out. And there's tons of it for sure in the religion. I know, just like, yeah, we're doing so good and Christ loving. And over here, you see the evidence of that. And that's
Just
scary to me.
take into perspective. If
Hmm?
Pryor is saying that Chad Daybell has requested 2 death penalty certified attorneys,
Mm-hmm.
John Pryor is his privately held attorney. In the end of all this, what did the judge say? The judge said,
Well, let me see. I'd have to go find it and I can replay it at the very end. Give me a
"No,
sec.
never about what Chad Daybell wanted. It's what the judge felt like was what John Pryor needed."
Okay. Well, and so we already have a live scheduled for later. So we're going to be able to talk about all this. I'm one that has to I have to think about it. I have to read comments. I have to kind of get a public or collective understanding, before I can even, and I'm not a damn attorney. Neither are you, you know what I mean? I get a better understanding. This is how I've learned throughout this whole process. Let me see. Stop screen. Present share.
Just to understanding.
Justice through understanding. You right, sister. Okay, let me scooch it on down. Yeah, somewhere around here.
For good cause. So we've gone through the procedural steps
No,
to
I'm
get
not.
here for this to be properly considered. The rule allows the court discretion where it indicates the court may allow for withdrawal.
I want to back it up to the right spot.
Defendant
Ooh.
All right, confirm the live stream's begun again. We are back on the record on KCR 2221-1623. The court has before it the defendant's counsel's motion to withdraw filed on January 11th. I've considered the motion along with the declaration in support of the motion. I've also considered the objection from the state. We conducted a hearing today where I heard argument from the counsel, Mr. Pryor, in support of the motion, the objection by Ms. Blake from the state. Also conducted a closed portion of proceedings and an ex parte inquiry of Mr. Daybell and Mr. Pryor. And I've taken all that into consideration in determining the ruling on the motion. The court first is governed by Idaho Criminal Rule 44.1, which under paragraph A talks about leave to withdraw. And I'll just quote that section. No attorney may withdraw as an attorney of record for any defendant in any criminal action without first obtaining leave and order of the court on notice to the prosecuting attorney and the defendant, except as provided in this rule. Leave to withdraw as the attorney of record for a defendant may be granted by the court for good cause. So we've gone through the procedural steps to get here for this to be properly considered. The rule allows the court discretion where it indicates the court may allow for withdrawal, and then looking at the standard of for good cause. So the court will first note to clarify in this case, this is a capital case. Idaho does have a separate rule governing the appointment of attorneys who are on a roster that are considered qualified to represent counsel or represent defendants in capital cases. That's Criminal Rule 44.3. And importantly, that rule only applies when a defendant is represented by a public defender appointed by the court and does not apply when a private attorney is retained in the case. And also importantly, where the court made reference earlier to questions about the mitigation phase, if that were to occur in this case under Idaho Code 19-2515, an inquiry to Mr. Pryor. And I'll note, and Mr. Pryor has correctly pointed out, that the ABA guidelines do apply to public defenders. They are not necessarily required to be followed by private counsel. Private counsel under Idaho rules are allowed to take on a case, capital case, and those guidelines may or may not be elected to be followed by a private attorney. Mr. Pryor clearly is a private attorney in this case, has never been appointed or publicly paid for representation of Mr. Daybell. Mr. Daybell importantly does have the right under the Sixth Amendment of the Constitution to counsel, and included in that right is to have the counsel of his choice. And Mr. Daybell elected a very long time ago to have Mr. Pryor represent him in this case. In fact, Mr. Pryor has agreed to take the case and has represented Mr. Daybell not only through the initial stages of the case here where the indictment was returned, but also in a previous companion case, and for I think about 3.5 years now, has represented Mr. Daybell. The court then going back to consideration of the motion before the court. There's an issue here that's been raised by the state about the timing, and of course the court joins in that concern also. Mr. Daybell has been incarcerated since June 9th, 2020. We've got a trial scheduled in 2 months. Mr. Daybell's asserted his right to that trial, and although he has waived his right to a speedy trial, certainly this case has taken a long time to get to trial, and at some point, even with a waiver of speedy trial, the court has to consider the timeliness of a defendant in custody being granted their opportunity for a timely trial. That right also applies to the state, and the state's right to seek justice for victims, to seek a conviction if they believe they have the evidence to do that, and to not have to wait through unnecessary and unreasonable delays in bringing a case to trial. So the court has a duty to try to timely administer cases, and while the rules generally slow things down a lot, there are reasons for that, but at some point the court has to consider the timing here. That's the big issue with this motion, quite frankly, is that the motion, if granted, would absolutely require a continuance of the trial and not just a brief continuance, because what would occur if I grant this motion and Mr. Pryor withdraws from the case, then under Criminal Rule 44.3, the court is required to appoint 2 capital qualified public defenders, absent Mr. Daybell having some manner of, again, rehiring a private new attorney or getting one to do it pro bono. The issue there is Idaho has a sparse number of attorneys on that roster, and Idaho is currently experiencing a lot of cases that are already resulting in appointments of a lot of available attorneys. And quite frankly, I don't have any idea who would be appointed of the 2. I don't have any idea when we could get them appointed. But what I do know is the trial would have to be vacated and would have to be continued, and I think likely for a long time, maybe a year, maybe even more. Because for new counsel to come in, start over from scratch on a complex case like this, not have any review of discovery or any preparation, they would have to reasonably request time to get prepared, which would have to be granted. Mr. Pryor was raising concerns about trying to get second counsel appointed. And I've tried to accommodate that, Mr. Pryor. We had a hearing, it was exactly a year ago, on January 19th of 2023, and talked about your concern. The way I interpreted Rule 44.3, while it doesn't really address a situation with a private attorney together with a public defender, I don't think the rule necessarily prohibits that either. And so I approved that you could have co-counsel if you could find someone, but of course, they would have to be on that approved roster because this is a capital case. I don't doubt that you've made a diligent effort to try to find co-counsel. That's clear to the court. I know we've addressed that over the course of the last year on numerous occasions, the status of whether or not someone was coming into the case. We're on the eve of trial and no one has come into the case. With that in mind, then, the court has to also look at the impact that could potentially have. If Mr. Pryor withdraws from the case, Mr. Daybell's required to start over, abandon an attorney-client relationship that's been ongoing for several years, start over with a brand new attorney-client relationship with someone that he doesn't know and we can't even tell him who that would be. And also with the delay, I find that that prejudices the defendant. I also would find that given all of the preparation and time that has gone into this trial setting, which has been scheduled out for a long time, made by both the court and obviously the state in being prepared and ready to go, that there should be a presumption that we maintain the trial date. So the two concerns here raised in the motion really are, number one, the fact that Mr. Pryor would not be able to obtain payment for his services. And the court does strongly consider that because attorneys work for their profession and it's important that they get paid, and it's a consideration. But that in and of itself does not, in my mind, rise to the level of good cause under the rule 44.1 to grant the withdrawal. The second, and I think more concerning issue, is some indication in the motion of Mr. Pryor indicating that it would be very difficult, if not impossible, to be adequately prepared for trial. That's what's set forth in the motion. However, upon argument here today also, Mr. Pryor has indicated that he has made steps. I don't find anything in the record that he's been ineffective in his assistance of Mr. Daybell's defense in the case. And so with the concerns today being brought up and addressed directly by the court, both in open and closed proceedings, I don't find any specific grounds indicating that Mr. Pryor has said he cannot and would not be ready and prepared to adequately defend his client, although it may be difficult and he apparently will not be able to be compensated. It's not in the record that it can't be done. And importantly also, Mr. Daybell has affirmed today he does intend and would like to keep Mr. Pryor as his attorney in this case. And finally, I'll note that in addressing these concerns at that hearing a year ago, there was a representation by Mr. Pryor who said directly to this court, and I'll quote what was said in the hearing, quote, "There's going to be no continuance because I'm asking to get out of this case. That will not happen." And the courts relied all along on those representations in getting this case scheduled. So in balancing all that out and looking at whether or not good cause has been demonstrated today, I do not find that there is good cause for withdrawal of counsel. And so under Criminal Rule 44.1, upon consideration of that standard, the court is going to deny your motion to withdraw Mr. Pryor. I will note that I've previously made an approval for a second chair. If one can and will join the case, then the court will permit that and we'll go through the procedure to get that properly done. So that's not a foregone conclusion. Given the timeliness of the trial, I understand that may be difficult. However, we are where we are with this trial setting, and because of the proximity of trial and the necessity of a continuance, if this motion were granted, the court finds that The motion fails to demonstrate good cause under the rule. For that reason, the motion is going to be denied. And Mr. Pryor, you will continue to represent Mr. Daybell through these proceedings. That'll be the ruling on the motion today, and I'll note that we do have more hearings scheduled and coming up, including motions and a pretrial conference. So, Mr. Pryor, do you have any questions on my ruling?
No, Judge, thank you for your consideration.
All right, thank you. Ms. Blake, any questions on the court's ruling? All right, thanks everyone for your attendance. That will conclude today's proceedings. We'll be in recess. All right.
So he's going to stay on, and they're going to find him some help.
Good. You're good. Chad needs help.
And they're going to get him someone. They're going to get him some help. I don't understand this whole thing about him not getting paid. He's not getting paid because Chad don't have no money to get him paid because he's privately held.
It's blood money, first off, but it is, somebody had asked that question earlier. It's one I've been asking forever now. And it's about, you know, if Chad pays for it with the money that he made, that he stole, you know, by murdering his wife, allegedly, and collecting on the insurance money that was raised on September 8th, 2019.
He's just going to have a lot of,
he's going to take it out of his ass.
they'll take it out of his commissary. They'll take it out
Well,
of
no, I mean, that's the charge. He's, you know, in a court of law, he'll get found guilty and he'll pay time. We all know Chad, I mean, what'd he make? $2,000 a year selling books that he was going to make movies on. He met with somebody to make a freaking movie in May of 2019. Okay. That is just bold. You just, oh my God, you know,
Speaking of books, I think we should incorporate a chapter for each of these freaks.
There you go. Chad, we hate your books.
Just with the knowledge that they would pick up a copy just to know what you're saying about them.
Oh, right. Right. Yeah, we hate your books, Chad. Everybody hates your books. And so it looks like there's pros and cons and everything, right? Well, you see Pryor down there in the bottom right corner. We get to see that for 6 more weeks. I'm joking. That's a joke for Groundhog Day. But anyways, we'll take him. There's Chad.
I never wanted John Pryor to leave.
Right.
I never did because I know that him and Chad's had plenty of talks, and I think he's going to chew the cult a new asshole.
And I mean, that's bad because that's what I'm saying. Sometimes it seems like I'm siding or whatever. No, with like the defense, but no, but that's because
we want answers.
We want answers. And that's justice through understanding is what that is. And again, I can want in one hand and, you know, with the other.
There are a lot of the answers that we will get. It will hurt us.
Look at what all we've, you know, I guess purged from this just by not stopping. People want us to stop talking about this stuff.
Oh, yeah.
There's nothing to see here. There's nothing to see here. Nothing's broken. Everything's great. And
I look at it like this. And I mean this with all due sincerity. The channel that I open, not everyone is welcome, but not everyone is welcome, but everyone is welcome.
Wait, not everyone. Everybody's welcome, but not everybody will. I don't know. I forget how it goes. This is, you know, just a little network around Chad and Lori. This is all the rest of them. This is the rest of them, so to speak. It's very concerning. In my opinion, it is. It's very concerning. It's not just a Utah problem. It's not just an Idaho problem. It's humanity, and it's our people in this country, you know,
I
that
guess
live on our streets. And
I guess the question is that at one point John Pryor wanted, I mean not John Pryor, Chad wanted 2 death penalty certified attorneys, which I don't believe. I just think that's what was thrown out there. And now Boyce is saying, you know, we'll get you some help. Where's that help going to come from? Is it going to come from John?
we're going to go over that tonight because I've got that pulled up. I don't know.
Finish up saying is that even if John Pryor walks into an office with Chad and says, here's our new second chair or whatever, Chad might not like him, or Chad could say, I only want this person, and this person could be one of those wigged out freakazoids.
True. I don't know. But anyways, so we're going to go live tonight at 7 Central. So that's 8 Eastern, 6 Mountain, and 5 Pacific. And we can discuss more on this then. But here is a reminder to the problem that we have going on. And we're just going to leave out on this note. Y'all leave comments. And I'm going to go scrolling through them to see what I can, you know, who has the best, you know, we'll bring up the best comments or interesting comments. And, you know, I can't talk right now. So I'm just going to end it. But anyways, thank you, mods, so much. You guys are awesome. Thank you, chat. You guys are also very awesome. I'm blessed. Totally. KJ, thank you for being here. And justice for Tylee, Charles, Tammy, JJ, and Joe. Love always wins. And you guys are proof of this.
And
Jesus
guess what?
Christ knows the truth of what
Are you
happened.
here?
So this is a mind-blowing development in the Chad and Lori Daybell case. So this is them sundating the day of their arrest. And this book right here, I'm going to tell you what's inside of that book and how it basically explains everything about this case. So Visions of Glory is a book that has been sold in LDS bookstores. It claims to have a stamp of approval by an apostle. It also claims to be a prophetic book about the last days leading to the second coming of Christ, which is what Lori and Chad believed was happening right now. At one point, the book explains that people will be so ripe with iniquity because they've been overcome by evil spirits, and that the most righteous thing that you can do for them in that state is to, quote, deliver them from mortality. I will play a clip for you now.
There was a law we followed. It was not a rule, but a law. When an individual or group threatened us, we knew their hearts. If there was any hope, even the slightest hope that they could be saved, even in the most celestial sense, we did not harm them. When we were confronted by people who were fully ripe in iniquity, and who would never repent, then we were free to deliver them from mortality. Their death would then be a blessing to them. Their death would be a blessing to them, because they could no longer add additional iniquity to their divine ledger.
Yikes.